we're sitting here in a museum, so it's very appropriate to talk about what I'm going to talk about. I think that people visit museums for a variety of reasons. One of them certainly is to visit, to look at ancient treasures. And I was lucky enough to have an hour or so before this talk to look through the University of Pennsylvania's museum, looking at just that ancient treasures. Now, what would happen, I'll pose to you, and today I'll be posing quite a few questions, answering some, but really leaving a lot for you to just think about and digest. What would happen if some of the treasures in this very museum were the subject of a lawsuit and were sold at judicial auction? In other words, a court said, those don't belong to the museum, they belong to somebody else, and I'm going to put them on the judicial auction block for the highest bidder. Should we allow that? Should we not allow that? And why and why not? Now, this very situation has become the subject of a lawsuit that I've been involved in, and that's the subject of my talk here today. I've been on the legal team representing the government of Iran for the past several years in a case pending in Chicago called Rubin versus Iran, as Brian mentioned, where a group of plaintiffs won a default judgment, and by default I mean Iran didn't show up by default, against Iran, and they have asked the Chicago court, this being a federal court, to seize collections in the hands of certain museums in Chicago and put them on the judicial auction block for the highest bidder to purchase in order to help satisfy that default judgment. Now, there's no guarantee, of course, that these, if they're permitted to be put on the auction block, will be sold as a collection. So it could be that one piece goes to so-and-so and another piece goes to another person. So the collection, as it is today, could be split up into many, many pieces, of course, diminishing its value with each split. So let me go back and explain the background facts of the litigation so you'll have context of how this came about. In 1997, a suicide bomber was, unfortunately, took out some of his suicide bomb in Israel and injured more than 200 people and killed 5. Some of the victims and their families decided to sue in United States court in 2001 in Washington, D.C. And the entity that publicly took credit for the bombing was Hamas. But they didn't sue Hamas. They sued Iran because they claimed, that is, the plaintiffs claimed, that Iran had provided funding to Hamas and therefore wanted to hit the deep pocket, as it were. So, Iran, as I mentioned, did not appear in that lawsuit, and we can speculate as to why that is. I was not involved at that time. So following a one-sided trial, a default judgment was entered in the amount of approximately $71 million. Now, at that time in the law, there was no punitive damages permitted against a foreign sovereign, but it might have been a much higher amount of a judgment had punitive damages been permitted. So this is just compensatory damages. So the plaintiffs had their judgment in hand against Iran, but how does one go about satisfying a judgment? It's not like you can go and look at their bank account or go and look at their house that they own in Philadelphia. You have to find out where their assets are. And since the judgment was issued in 2003, they've been trying to do just that. They've been trying to satisfy the judgment by going after Iranian assets in the United States. Now, how does one go about doing that? Well, I don't know what the plaintiffs' methods are to find out our assets, but I do know that they have filed suit in several different places, one being Lubbock, Texas, where they successfully got the Crown Prince house, and they won $400,000. So $400,000 toward a $71 million judgment, kind of a drop in the bucket. So now we come to the ancient treasures. Because they weren't satisfied with just getting $400,000 to whittle down the $71 million judgment, they decided, that is, the plaintiffs decided, to find other assets of Iran's in the United States. Well, they happened upon an article, as I understand it, this is not first-hand knowledge, which talked about a return of some of Iran's artifacts that were here in the States to Iran, having just finished an academic study. And so they said, aha, we want to go after those artifacts, prevent them from being sent back to Iran. They belong to us because Iran owes us $71 million, and let's put them up on the auction block. So they filed a couple of lawsuits, one in Boston against Harvard and the Museum of Fine Arts. They also filed a suit in Chicago against the Field Museum and the Oriental Institute at the University of Chicago. And you might find it curious to note that they also registered their judgment. That is, they said, we have this judgment here in Philadelphia. We can speculate why. I just today looked around the museum and I saw that there's an Iranian or Near East section, Islamic and Near East, I think it's called, here at the University of Pennsylvania. So I'll come back to that point in a minute. In any event, the plaintiff's main argument in both the Boston and the Chicago portions of the litigation is that the museums have in their possession antiquities that are owned by Iran, or in which Iran has some sort of interest, even if not full ownership, and because they're Iranian assets, may be taken by the courts and sold at auction so the plaintiffs can collect more money. Now, the legal theories in both the cases as to why they're what we call attachable, and by that I mean you can take them and sell them, they do have some crossover, but in all events, the core issue in both cases is the one I posed earlier, which is, can antiquities, in this case Persian antiquities, be awarded as commercial assets to satisfy a judgment which has nothing to do with those antiquities? So it's not like there was some lawsuit that was based upon these particular objects. It was a terrorism lawsuit. It was resulting from a suicide bomb. I'll also note that the objects have been in these United States museums, including the University of Pennsylvania, for purposes that also have nothing to do with terrorism, but they're here for scholarship, academic loan, studying, or, as today I saw, display. So now let's discuss these two cases and the plaintiff's legal theories, and I'll try to keep the jargon at a minimum, but certainly let me know if you have a question about a particular term. Oh, sorry. Scared me. I'm keeping that here so I don't talk and talk and talk and talk. Now keep in mind there's two hurdles that the plaintiffs have to get over in order to win. So they haven't necessarily won outright yet. One is they have to show that the objects are in fact owned by Iran. That has been difficult for them. Second, if they are owned by Iran, they have to show that the objects are not protected by some U.S. law from being attached. So both of these bridges are necessary. And let's talk first about the Chicago case, in which I have been involved against the Field Museum and the University of Chicago. There are three collections at issue in the Chicago case: the Persepolis collection, the Hertzfeld collection, quote unquote, and the Chokamish collection. Starting with the Persepolis collection, that is a collection of ancient Persian artifacts, as to which there's no dispute who owns them. So plaintiffs get over the first hurdle without any discussion. Iran owns them, and Iran has come out publicly to say so. The University of Chicago agrees. It's because they were part of a long-term loan. Iran said, you guys are the experts, study them, let us know what they say, ship them back when you're done. Well, that started about 80 years ago. So even though they've crossed that first bridge, they'll still have to show that they are not protected by some U.S. law from being attached, even though they're owned by Iran. You may already know this, but Persepolis, I had to learn this as part of the case. Persepolis is an ancient city built by King Darius I in 515 BC and destroyed by Alexander the Great only 185 years later. So it had kind of a short life, but it really is an amazing place, and some of the artifacts that have come out of it are very important to Iran. I mean, it would be like an equivalent of the United States, I always say, is our Constitution. You know, very, very important artifacts to Iran. the University of Chicago in the 1930s led an excavation at Persepolis, and through partage, the sharing of findings, they kept some artifacts, and Iran kept some artifacts, and then they had this agreement where the university would study some of the other artifacts. My understanding is that there are very few people in the world who speak Elamite, which is the language that is written on these artifacts. So the university does employ some of the people who actually understand and can decipher Elamite, and they've been doing that for the past how many ever years. Some of the interesting findings, as a sidebar, that they have found are that the tablets are administrative records, and I want to quote what the Oriental Institute's website says. One record shows that it's food rations for every level of society, from lowly workers through bureaucrats and governors to the royal family itself. So I find that very interesting to see how much food was rationed to the lowly worker compared to the royal family. And that's written in these tablets. So, as you can see, this is very important, probably worth a lot of money in certain communities, and certainly worth a lot as a matter of cultural heritage. Now, the plaintiffs argue that they have the right to take these artifacts because the university has been acting as Iran's, quote, commercial agent. Now, Iran says that's nonsense because the university has been studying these things on its own without any direction from Iran. I mean, that was the point of the loan, for the university to do work. But that's the plaintiff's argument, and they claim that the act, which Brian mentioned I do a lot of work in, the Foreign Sovereign Immunities Act, gives them a right under the commercial activities exception to take these artifacts. Now, the commercial activities exception is basically when a foreign nation is acting like a commercial player, a contract, it engages in a contract, as opposed to like a sovereign, for example, issuing currency. You and I can't issue currency, a sovereign can, yes.
So does commerce include contracts in which no money or goods change hands?
Well, commercial activity has been attempted to be defined by the Supreme Court. It is a litigated term, so when you're asking for a definition, it's the subject of many, many lawsuits. But the going definition is kind of like I've just described it, where a court will look to determine if the sovereign is acting like a commercial player. So it depends on the contract.
No, does commerce include money? Does money have to be involved?
It does not necessarily have to be involved. Yeah.
But in this instance, isn't it because the University of Chicago published a book that was sold on these artifacts, and that's what they're using as a commercial?
Well, in this instance, yes, and also display. There's a case, not this case, a different case, where it was held that certain activities of a museum can be considered commercial. That has been the subject of a lot of debate, but display, selling a book that talks about the findings, those are all things that at least that one court has found to be commercial. It's still being litigated in this particular case, so the jury's out on that one, as it were. Now, I also want to explain a little bit about what immunity means in the context I'm talking about. It is just as it sounds, it's protection from something. So you're immune from disease, you're protected from the disease. In this case, a foreign sovereign would be immune from certain things that it would otherwise be forced to do as a commercial actor. So that's what I mean by immunity. The reason why we have this act is because of another term called comity. And that's not comedy haha, it's C-O-M-I-T-Y. And it means basically the golden rule. So do unto others as you would have them to do unto you on the foreign relations scale. So the United States doesn't want this happening to them abroad, so they're trying to be careful about what happens to other nations in its courts. And just to give you kind of a real-life example, if, for example, when Hungary changed its currency in the 1940s from the pengo to the forint, should we, the U.S. courts, be determining whether that was lawful? That's for anybody to debate. Similarly, should a Russian court be determining whether the actions that the United States government took to the financial crisis a few years ago were lawful? These are the kinds of things that go on in some of these cases. They're litigated issues. So let's return to the plaintiff's argument in the Rubin case in Chicago. Essentially, they're saying whenever a U.S. museum studies the antiquities of a foreign sovereign and publishes its findings, sells a book, puts them on display, does something commercial, then they can be taken by a U.S. court because the university or the museum is then acting like an agent of the foreign sovereign. That's their argument. I'm not saying it's right. The U.S. court hasn't said it's right. That's just their argument. Now, you can imagine that this has many implications for both the sovereign and the museum. I mean, the museum's kind of caught in a crossfire here. And one implication is that the foreign nation or the museum might be afraid to make the loan or take the loan because of things like this happening in the future. That concern is definitely not hypothetical. In 2008, the Metropolitan Museum of Art in New York had an exhibit titled Beyond Babylon, Art, Trade, and Diplomacy in the Second Millennium BC, and it was supposed to display 55 cultural artifacts from Syria. Well, Syria, like Iran, has been designated a terrorist nation and has some of these lawsuits against it as well. And so they withdrew the 55 objects, and on the wall of the exhibit, the Met had written, "We express our deep regret that recent legislation in the United States has made it too difficult and risky for these planned loans to proceed." So this is real life, a lawsuit coinciding with a museum. So let's summarize where we are, just talking about the Persepolis collection. The first bridge they've crossed, Iran owns them, no dispute. The second bridge, still up for grabs, whether they can take them or whether the FSIA, that is the Foreign Sovereign Immunities Act, protects them from being taken. Now let's move on to the next collection, the Chokamish. This is a grouping of artifacts also on loan by Iran. They've also crossed the first bridge. Everybody agrees that it's owned by Iran. When I say everybody, I mean the university and Iran. As it turns out, the plaintiffs disagree, which is a little ironic because they're retracting from the first bridge. Their theory is that there's a secret title dispute going on in a tribunal in The Hague. And let me back up a little bit about why there is even a tribunal in The Hague at all. After the Iranian hostage crisis, there was a settlement between the United States and Iran called the Algiers Accords in 1981. And as a result, they set up this tribunal where people could make claims, directing claims to that tribunal. That tribunal sits in the Netherlands. And it's still active today, how many ever years later. So one of the claims was Iran said in a modern-day lawsuit in The Hague, the United States hasn't done enough to help us get our Chokamish collection back. The university tells us they're done studying it, we want it back. We're going to sue the United States in The Hague tribunal. Well, the plaintiffs found out about this, and they said, aha, what's really going on behind the closed doors of that tribunal is there's a title dispute. Now, I couldn't tell you who claims what title, but I just assume that the United States or the university has gone in there and said, actually, the university owns the collection, not Iran. That's important because under their second theory of attachment, the plaintiff's second theory of attachment, they're trying to use another law called the Terrorism Risk Insurance Act. I'll call it TRIA. Under TRIA, the plaintiff's interpretation of TRIA, if there's a title dispute, then an asset may be subject to attachment. And that's because of a lot of regulations that they bore me, so I'm not going to even talk about them, and I don't want to bore you. But essentially, they're saying, the plaintiffs are saying, there's this title dispute making the artifacts contested of who actually owns them. And therefore, they get to attach them under this TRIA law, which allows for attachment of certain blocked property. And by blocked, I mean blocked by the United States. So To Iran, this argument really makes little sense because Iran says they own it, the university says Iran owns it, so it's plaintiffs who are coming up with a title dispute. Again, I leave it to you to ponder whether we should permit that. Should we require the actual people who have the right to say they own something? You know, if I'm sitting here and I look across the room and I say, I own that shoe, okay, that's fine. But if you say, she owns that shoe, and I say, I don't care if I don't want that shoe, should you have the right to step into my shoes, essentially, to pick up on the shoes? Okay. Find where I am.
I have a question. Do you have an entitlement law that says that if I have an item that belongs to my family, is that the case to, like, if somebody owns it, like, centuries and centuries?
Well, this doesn't involve so much an artifact being in somebody's family. In this case, it's more like patrimony. It's something that's owned by the state. So I will talk later about an issue that kind of gets to that, but it's a little different because it's not owned by a family. Does that answer your question?
Yeah.
Let's move on to the Hertzfeld collection, where we will be talking about that kind of thing. This is not truly a collection in the same sense as the Persepolis or the Joachim. This is just a group of artifacts that we're calling that because a man named Ernst Hertzfeld, who was a renowned excavator of Iran in the early part of the 20th century, allegedly stole a bunch of artifacts from his digs in Iran, brought them back here, and sold them off to a bunch of museums in the States. That's the allegation. I don't know if it's true. Included among the museums that he allegedly sold these things to surreptitiously are the Field Museum and the University of Chicago. And so they have in their collections these Hertzfeld items that the museums say we own free and clear. There was nothing funny business about it. But the plaintiffs are, again, the ones coming in my shoe example and saying, haha, Iran really owns those. And under Iranian law, patrimony law, to get to your question, anything unearthed in Iran is part of Iran's cultural heritage and by law is Iranian owned. Well, in this situation, Iran hasn't come in and said, we own these, don't take them. In fact, Iran has not made a claim to those artifacts. But instead, the plaintiffs are coming in and saying, under Iranian law, they're Iranian owned, and therefore, we get them. Now, how do we get to the title dispute issue? Well, the university has come out, and the Field Museum has said, we own them. And the plaintiffs are saying, aha, title dispute. Where is the title dispute, I would ask? Iran doesn't say they own them. The plaintiffs say Iran owns them. So, that's where the Hertzfeld collection is. This argument, as you can imagine, also raises some serious problems for museums. They are, the plaintiffs are the ones creating the title contest, not Iran. And should we permit, as I posed earlier, the third party to make the ownership claim rather than the foreign sovereign? Let's come back to this museum as an example. So let's say that the plaintiffs take their judgment that they've actually registered here in Philadelphia and file a suit against the University of Pennsylvania saying, I saw your room down there and I see that it says they're from Iran. I think that Iranian law means Iran owns them. Cough up all your stuff and tell me that Iran doesn't own them. Well, the museum might not take very kindly to that, and to get embroiled into litigation, which, by the way, is very expensive. And this lawsuit started in 2003. That's when they got their judgment. 2013, that's 10 years. Just it takes a while to wind your way through the courts. Yeah.
You keep referring to the plaintiffs using Iranian law as the support for their assertion that Iran owns these things. But in fact, first of all, have they demonstrated that? And second of all, at least my knowledge of the antiquities law in Iran is that it has evolved, but certainly at the point of Hertzfeld's time, the only things that were protected were, in fact, architectural monuments, and that anything found under the ground in the Quran is considered to be, private property. It's not owned by the state. And that law has changed over the years, but still, Iranian law on antiquities is a very complicated and obscure business, and I just wonder whether the plaintiffs have really studied the Iranian law and may have a case for that.
Yeah, well, as usually happens when there's an issue of foreign law, U.S. courts, believe it or not, can make decisions of foreign law. It sounds very strange. But what will happen is experts will file opinions. So if the plaintiffs have, in this case, their own Iranian law expert, and the defendants get their own Iranian law expert, and the two are Iranian lawyers looking at the laws, and they tell the court, this is our interpretation of the laws, and the court then decides, which may be strange to our ears, to hear that maybe in Iran, a judge is looking at a U.S. law and making decisions. It just sounds a little odd, but that's our system. Okay. Another interesting aside, and this really it's not a cultural property case, but just so you know, the United States has been a defendant in a proceeding in Spain, in which the plaintiff was seeking to attach some United States properties in Spain. And the United States argued, based on the UN Convention on the Jurisdictional Immunities of States and their property, that, quote, any property forming part of the cultural heritage of the state or its archives and not placed or intended to be placed on sale is presumed to be immune from attachment. So the United States has taken a position in a lawsuit abroad saying this should not be the subject of a lawsuit. Recently, there's been some attempts at some legislation to try to shut down these types of lawsuits where cultural artifacts would be the subject of attachment proceedings against foreign nations. It went through the House, it got passed by the House, and then it didn't make it through the Senate, and now we have a new Congress, so it would have to be re-proposed. And as far as I know, it has not been re-proposed, so that's out there. Now I'm going to talk a little bit about some of the other problems for museums and sovereigns alike that this lawsuit has created. When the litigation first began, the plaintiffs were litigating just against the museums. And Iran, as I said earlier, had not entered an appearance in the case. They were just staying out of it and letting things happen. The museums went in and said, there's the Foreign Sovereign Immunities Act, there's all these immunities because they are sovereign works. And I'm talking about the actual admittedly owned by Iran works. And therefore, those are protected. And we should be able to argue that they are protected under those laws. Well, the court disagreed and said, no. If Iran wants to argue those laws apply, Iran's got to come in here in my court and tell me so. And so that's how Iran came in and made its appearance. Iran said, all right, we're here now. And so we want these laws to apply. That ruling then led to some more results that were bad for the sovereign's eyes. The plaintiffs took that opportunity, now that Iran had made an appearance, to say, all right, you won't give us these artifacts, you won't pay the judgment voluntarily, so please tell us everything you own in the United States in what's called general assets discovery. Now, it's fairly common if Brian were to sue me and he won, that he could take my deposition and say, tell me your houses, tell me your jewelry, tell me everything you own, and he would have the right to ask those questions.
I have a question. When you say state, does that include the Ayatollah Khomeini?
Another litigated issue. The United States makes the determination from the United States perspective what it considers to be a state. So, just as an example, the United States recognizes the People's Republic of China as China, not Taiwan. That's just an example. So, it really depends on who you're asking and what the United States has decided. But to get back to general assets discovery, that's exactly what the plaintiffs did. They said, tell us everything you own. Well, Iran said, no way. We're not going to give you a list of everything we have in the United States. Put on a different hat. I mean, Iran is kind of a hot button issue. So put on your hat if you are a U.S. citizen. Imagine the United States in a place like France, a friendly nation, and a French citizen were to say, tell me everything that you have. You can imagine some of that is classified, secret, concerning, whatever it is, you know. So it's not going to be open kimono, I guess is my point. Well, the court disagreed and said, you do have to open your kimono, down to the paperclip, tell them everything you have. And Iran fought it tooth and nail. And what we did was we had to appeal it to the 7th Circuit Court of Appeals, and we won. And the reason we won is because, as the 7th Circuit recognized, Iran is different than the lawsuit I was describing between Brian and me. They're not an individual. They're a sovereign. They're not a commercial player unless they're shown to be a commercial player. So the baseline presumption is that a sovereign nation is immune from everything. And then you have to show that they're not immune as a plaintiff in U.S. courts. Yes?
I think what's missing from what I hear is history. It is not for nothing that a nation is being called a terrorist nation. For example, in the 20s and in the 30s, when the Soviet Union was not recognized by the United States because they were officially a state created for the purpose of destroying the world. That was their hymn, that was it all about. So they were not recognized, but then they kept selling national treasures in the United States for millions, hundreds of millions, and billions of dollars. And the money was used for preparing to war, for preparing the Second World War, and actually starting it, for armaments. Now, it was legal or illegal, it was a terrorist nation, and it was allowed to do what it did, and these are the results. So humanity lost something, but also learned something since then. Not all nations are equal. Today, the Russian people condemn the Russian government that sold national treasuries for billions to prepare the war that costed Russians 35 or 50 or 40 million people dead. So the United States, when it determines that Iran is a terrorist nation, there is something to it. It is not the same like suing like France and the United States or England suing each other over cultural treasures. There is a history. There is what's called a civilization, and even the concept of a museum, how it was born and what it exists for, it has very clearly defined roots. You cannot discourse in abstract.
That's absolutely the position of the plaintiffs. They would absolutely say, this is a terrorist nation. We should not be treating it the same as other nations. And the courts differ on that. They say, nation is a nation is a nation. Now, there's certain laws that have been enacted that address just terrorist nations. So to be sure, Congress has treated terrorist nations differently. But when it comes to immunity, it's so important in the eyes of the courts to maintain immunity across the boards to the extent they can within U.S. law, that they have upheld certain rights of even those nations that are considered terrorist nations. So it's a matter of debate. Yes?
To follow up on that point, and not to dismiss the historical dimensions of the example of the Soviet Union, or even now of Iran and its activities in the Middle East and elsewhere, even if you're considered to be some kind of a commercial player for the University of Chicago, the Field Museum, Iran was a different nation at the time those contracts and those artifacts were actually were given over to Chicago, permitted to be taken out of the country, and so forth. So the historical, so that part of history is also part of this record.
do justice to the laws. And one of the laws is that, based on this concept of golden rule comity, we treat all nations the way we would want to be treated. And the concerns, the policy concerns behind that, they try to leave those as much as possible to the politicians. So I think that's a really good point, that maybe doesn't feel quite as bad if it's a loan then. I mean, query whether we should, if the loan was something modern, whether we should still treat it the same. I'm not answering the question, I'm just throwing it out there for general query, yes.
Quick question, who are the plaintiffs? I mean, who are they? How are they involved in this terrorist case?
They were victims of the suicide bombing. American people who were either victimized themselves or their family members.
They were in Iran, or where was the bombing taking place in Israel?
It was in Israel.
Excuse me, is that the reason why it's being tried in a U.S. court? Is there not a world court other than The Hague that this can be bounced to?
Well, that's a really good question. There is a concept called standing in the U.S. court where you have to have some connection to the suit, that's standing, and as a matter of constitutional law, you have to not apply your laws extraterritorially. But in this situation, some of the people were U.S. citizens, and the law, the revised law, not the one they were suing under, actually permits suit in some situations where they're not U.S. citizens, but they have some U.S. connection. And I believe, I'd have to look up the case where it actually held this, you don't necessarily have to be a U.S. citizen to sue here under the Foreign Sovereign Immunities Act, so long as there is a connection to the United States in some other capacity. You can't have a suit under the Constitution between two aliens. So maybe a U.S. permanent resident or something like that. But that's another litigated issue. I know I'm sounding like a real lawyer where it says it depends, but that's so often the answer. Does that answer your question?
Yeah.
Now, what's really interesting about this case, as if there's not a lot that I've already said that's not interesting, the United States has taken a public position 3 times in this very suit. So the first time they came in and supported the museums, and they said, these artifacts should be protected, and we support the museums. Then, even after Iran came in, they filed what are called statements of interest. Now, in them, they don't say we support Iran. It's not like they're coming out publicly to say that. But the legal position they take is aligned with the legal position that Iran was taking. And the reason for that is because they're thinking of their own interests. It's not like they have a soft spot for Iran, hardly. It's quite the opposite. They always begin their briefs by saying, we deplore terrorism and we take no opinion on that. But these things are of major importance for this comedy concept that I was talking about. And including on the general assets question, they came in and said, in a statement of interest, no general assets discovery because we don't want to cough up our stuff either, basically. So as I said, the Court of Appeals ruled in Iran's favor in 2011, and that caused the plaintiffs to be restricted to the artifacts. They can't take general assets discovery. So now, believe it or not, it's back in the district court, and it's being litigated of whether the artifacts will actually be attached. So the ultimate question has not been answered. These things take a long time. They're in what's called discovery, which is documents back and forth, depositions, that kind of thing. Now I want to talk a little bit about the Boston lawsuit. So it's the parallel litigation by the same set of plaintiffs, but against Harvard and the Museum of Fine Arts.
Can I ask you a specific question about the case and sort of its incipients? So, I don't think anyone disputes that Hamas has not been behind bombing and not been perhaps behind this, and there's not a connection between Iran and Hamas in terms of support. Was it contingent on were the plaintiffs not required to demonstrate a direct connection between Hamas and Iran in the case of the bombing itself?
Yes.
Rather than as a general case, which I think, there's no evidence to suggest that's the case. Was this not something that was a dispute during the initiation of the
to Hamas. So absolutely they had to prove the connection.
That's been approved connection.
That was a proved connection in a one-sided trial. Okay, so talking about the Boston suit, that suit went a little bit differently. It wasn't quite as many twists and turns with the general assets discovery, et cetera, because Iran didn't show up. And the reason, well, a couple of reasons. First of all, Iran hasn't made a claim to those artifacts. Little different than Chicago, where they say, these are our artifacts. That's one difference. The other difference is, remember how I said in the Chicago suit, the judge said, museums can't argue this. Iran has to show up in my court and argue this. Well, the Boston judge held the exact opposite thing. The Boston judge said, the museums have the right to argue the immunities because the immunities belong to the artifacts, not to the entity. So, as a result, they went through the discovery of whether the artifacts were owned by Iran, all the things you were asking about, provenance, and Iranian legal expert opinions, Iranian law legal expert opinions. And the district court recently held that the plaintiffs had not shown that the artifacts were owned by Iran, and so the plaintiffs lose. Of course, the plaintiffs appealed that, and so in the First Circuit Court of Appeals, they just heard oral argument on that case in December of last year. And the way Court of Appeals decisions in the federal system work is you have a panel of 3 judges, and they'll hear the case, and then they'll write an opinion. It takes months and months. So it was heard just a few months ago, probably an opinion later this year. And believe it or not, the hottest subject of that oral argument was the meaning of the word of. So it's reminiscent of the Bill Clinton meaning of the word is in a very different context. But the debate was, does of mean belonging to, or does it mean somehow related to, associated with? The water of Lena Lopez, or the water of Lena Lopez, just associated with, and so that was the debate. The plaintiffs say the word of, and I'm referring to the statute where it says property of Iran. That was the requirement. Well, the plaintiffs say of just means that Iran has to have some flavor, has to have some involvement, and therefore they could go after these museum pieces because they are from Iran, originally. And of course the defendants say, and the United States, by the way, says of means belonging to, ownership, at least possession of something to show there's a real connection. The judges will decide. I don't know the answer. You'll get an opinion to see what of means. Now, I listened to the oral argument on the streaming, which you can do going on the internet. And one judge on that panel asked, well, how would this work? If the definition of is so broad, let's spin it out. This is not an example the judge used, but I'm just kind of picking up on the judge's question. Let's say we have a Persian rug. Well, let's say I own it, and it's worth $3 million, and it's sitting in my house. And I inherited it from my family, let's say. And they received it, and they bought it in Persia in the 1920s. If I don't have a receipt for that ownership, are they going to be allowed to take it because it's of Iran?
Yeah, but at the same time, Iran was called Persia, so you can fight that too.
Yeah, the boundaries of Iran have changed, that's true. And that could be
that could be a fight. You say that, oh, I didn't get my brother in Iran, it came from Persia.
But should the plaintiffs be permitted to go into individuals' homes and find things that are of Iran? I mean, that's a really broad definition. So we'll see how the courts decide, but it seems like it should be reined in a little bit. The lawyer for Harvard made a really interesting point that I wanted to raise. He said, if we go after assets in museums or in people's homes that are of Iran, aren't we really hurting the museums and the people? The entity that we want to hurt, or that Congress wanted to hurt, was Iran. So shouldn't we take things that are very clearly owned by Iran in order to punch them where it hurts? I mean, that's the point of the judgment. $71 million, in theory, is going to hurt them financially. And so stringent rules of ownership in order to make the policy of the lawsuits really worth it? That's just another question. Another question posed by that oral argument was, should there be a statute of limitations on these claims, a time limit? You know, these loans from the 1920s, 1930s, and Iran hasn't made a claim for how many ever years. Iran may know that there's artifacts sitting here in University of Pennsylvania Museum, and if they haven't said anything, but they're on display, maybe Iran doesn't care. Should we allow a plaintiff to come in and say, well, no, they haven't made a claim for 70 years, but now I suddenly am allowed to make this claim today? Who should bear the burden of proof? I think I mentioned earlier the strange circumstance where if I have the Persian rug and I don't have a receipt, should I be required to prove that I own it? Or should the plaintiff be required to prove that I stole it or that I didn't buy it, or somehow it is owned by Iran? Well, that's a debated issue in this very lawsuit. So the plaintiffs are saying the museums, if they don't have enough records of their provenance, cough up the artifacts because we haven't proven it. Whereas the defendants are saying, no, plaintiffs, you've got to show that my provenance is no good. Yes?
If a plaintiff is claiming that something was stolen 100 years ago, is there a statute of limitations in American law?
Well, there is. And it can be a very tight statute of limitations, 3 years, for example. Like I said, the plaintiffs are saying that shouldn't apply. American law is no good here. It's Iranian law. Or it should be some sort of tolling where there hasn't been a claim until we made a claim. So, now the plaintiffs would also make the point that, hey, don't take all this out on us, museums. If Iran were to just make the payment, we go away. So the plaintiffs are basically saying, we're victims of a suicide bomb. You've got to be kidding me that the museums are coming after us. And by that I mean just politically the museums don't like this stuff. So there's been kind of a tension between the plaintiffs, who are sympathetic plaintiffs, and the museums. So again, I leave that for your debate. Should we favor museums because cultural artifacts are something so sacred to us as cultures? Or should we favor plaintiffs who have suffered terrible losses? I have watched portions of a movie called, well, the entire movie called Rape of Europa, but one little portion stuck out in my mind of how important cultural artifacts are. And I'll just kind of leave this with you. You can see footage of the winged Victoria Santa Thrace being wheeled down this creaky ramp back when it was being evacuated in World War II. And what struck me, it was an amazing feat of getting the winged Victory to safety, but also that the statue is not French. So it's at the Louvre. It's not French. It's a Greek statue. But they recognize how important it is to save this thing from destruction. And nobody's talking about mashing up these tablets of Elamite and destroying them. But in a way, separating a collection is a form of destroying at least its value. So that struck me to watch that segment and in the context of this case. And I hope that this has been informative and interesting for you all. Happy to take other questions or debate.
We have about 10 minutes for questions, so if people have additional questions, please.
I'm interested in knowing the, not necessarily the name of the firm, but is it an American firm for the plaintiffs?
Yes, yes.
Is it in their concept? I mean, just understanding it's where you can get the best bang for your buck. So having this in an American court would be much better than having it in a court in England or a court somewhere else, with everything that is so known about how much these artifacts can be worth. So no offense to your profession, but lawyers do love to do their research and to search out what possibly is going to get them the biggest amount. So to me, it just makes more sense that Americans would, or an American firm is saying to these plaintiffs, and yes, it is a horrible thing that happened, better to carry it out here than in the state of Israel, right? Is that without any emotion in it? Just being very...
The law, they saw a window. They saw a law.
Yeah, they saw a window.
And the law, they claims, provides them with all these rights. And they wanted to make a statement, and they wanted to get everyone's attention, and they want their money. So
the people that are making the most out of this are the lawyers.
Well, I don't know. I don't know how their fee arrangement is.
So this next, whatever from this appellate court, is that it, or the district court, will give something within it?
Well, the appellate court usually will say yes or no whether the lower court got it right.
Okay.
And if it says the lower court got it right, that is, in the Boston situation, the artifacts are not Iran-owned, so plaintiffs have to go elsewhere, then that's basically the end of it. You can take it up to the Supreme Court, but the Supreme Court has special rules, so it's not likely to go there. But let's say the Court of Appeals disagrees. Well, they'll send it back to the lower court and for some sort of more litigation to determine how to give the artifacts to plaintiffs. And to answer your question about the lawyers, I don't know if they're on what's called a contingency fee basis. By contingency, it's fairly typical in like a car crash case, where a lawyer, the person, the individual might not be able to afford a lawyer to sue. As I said, litigation is very expensive. But on a contingency fee, the lawyer will front the costs, and in the event of victory, the lawyer will collect 33% of the take home. I don't know if that's their situation or not. Yes?
You're obviously very close to both these cases. I'm just wondering what your opinion would be of where both the Harvard and the Chicago case will go.
Yeah. Well, it's interesting because in the Chicago case, there was the case had been sent by the district court judge to the magistrate judge, so most of the proceedings were before the magistrate. And he loved the case, he was fascinated by the case, but he was clearly biased against Iran, and he wanted to find for the plaintiffs. Now, I don't mean bias in the way that he should have recused himself. I just mean all of his findings were going against Iran and toward the plaintiffs. So there was no doubt in my mind that had we been before him, we would have lost. As it turned out, he died of lung cancer recently. So the case was moved to a different judge, and I have no idea how he'll rule. In the Boston case, I mean, sometimes you can read the tea leaves when you listen to an oral argument. And in this one, probably they'll find that the word of means belonging to. Whether they find something tricky about, the Iranian law experts and some error there, I don't know. But I think it would surprise me if they went in favor of the plaintiffs in that.
Just as a follow-up question to that, has there ever been any discussion of who actually is being punished here, whether it's the Iranian state or the Iranian people or the world that's having access? Because these will pass into, I presume, private collections.
Well, certainly that discussion has taken place by museum-type communities and other people, not necessarily in the actual. The lawsuits tend to stick to the boring parts of the law. I find it interesting, but it's not the sexier stuff like that. Yes.
It's kind of scary because I feel like if found against the defendants, this is case law that's going to be used in future cases, and it will be a slippery slope against museums and things like that.
Yeah, absolutely. The way it works in the federal system is if you're in what's called the Seventh Circuit, which hears cases from that circuit of states, it will be precedent in those states. So in Chicago, this is binding precedent. The decision in favor of Iran, that is. And same with the First Circuit, which hears cases from Massachusetts, Maine, and that whole area. But they're also persuasive, so even if it's not binding, you can cite a case from the First Circuit to say, hey, look what happened over there. Shouldn't you consider that and rule that same way? So if there's what's called a circuit split, where the First Circuit disagrees with the Seventh Circuit on the same issue, that's the kind of case the Supreme Court will resolve. Yes?
I was wondering if when these objects are sold, can there be stipulations put that a museum can buy them or it was private, and could Iran buy them back?
I would be very shocked if they would allow Iran to buy them back. They could, but that would be an interesting way to get Iran to pay the money. But I don't know the answer to that. I don't know how a court would structure a judicial auction that had some sort of limits on it. I certainly have never heard of that, but this case has caused all sorts of new things. So maybe, yes.
If this remedy doesn't work, say, and I recognize you're representing a foreign country, but if you're an American citizen and you have had a family member blown up and you come to court for a remedy, this is really about reparations to terrorist victims. What would you recommend as a remedy for reparations for these victims instead of cultural heritage?
Well, I won't necessarily give my personal opinion, but what I will say is that one tact that other groups of plaintiffs have taken is not necessarily to use the courts, but to go through diplomatic channels, which is there have been global settlements with other nations between the U.S. and Syria, for example, or Libya,
Yes.
where there was a global settlement that paid out victims and also settled difficulties between the U.S. and Libya. So that's another way to do it. If the lawsuits don't work, go through Congress, the State Department.
One of the reasons why I ask is because now we have a history here of paying, either the United States government paying reparations to victims, to our citizens in other countries who have been hurt in other countries or who have been victims of terrorism here. We're now setting a precedent to where we as taxpayers are all responsible for paying for these. So if you're an actual foreign country who is responsible, like Libya, why should we not use the court system our court system to look after our citizens? I'm playing devil's advocate.
Oh, sure.
Because if we don't want our cultural heritage, if we don't want everybody's cultural heritage attached and up for grabs, then what can we do as a sensible remedy for these people?
Yeah, keep in mind, Iran's kind of a unique situation because as a result of the hostage situation and some of the fallout more recently, I mean, it's not like that. After that was resolved, they were getting along great. Iran and the United States have had problems for years. And so there's just not a lot here. Now, Iran doesn't have a bunch of assets here because everything's blocked or sent out of the country or whatever.
Right.
But I think the bigger concern is for other nations that have stuff here and are not kind of the blacklist like Iran. So probably the answer would be from a policy standpoint beyond just the four corners of Iran. Yes?
Is it too late in the proceedings for Iran to give up its claim of ownership? Say simply, we give it to the University of Chicago.
I don't think it's too late. Nothing's, sure, they can give up this money.
Then what would the plaintiffs do then? Would they give up their claim or what?
I think they'd have to, because they wouldn't be able to satisfy that first hurdle of ownership.
I'm still not convinced that they're going to give the claim, what you say.
Right. Depends how you define the word of.
Pardon?
Depends how you define the word of.
Well, the Chicago and the other jury have that. It just seems to me that the opportunity by the lawyers on the other side proving that Hamas is there an arm of Iran. Come on.
Yeah, you're not alone in feeling that way. There's a lot of people who feel that way. I saw another, yes.
What's the likelihood that this is going to visit us here at the
Well,
Penn Museum?
good question. I mean, they registered their
Right.
judgment here.
Right.
They registered it a while back.
Right.
I'd say 2006.
Right.
So you'd think that they would have made this a kind of a trio of cases.
Right.
But maybe they're using the other two as test and see if they get results, and if they do.
Because the almost all of the material we have from Iran is through documented partage, right? And
Well,
so, depending on what happens with, say, the Chogamish material, our Hasanlu material and Turin Tepe and all of the rest, all of that material, or most of that material, came under the same circumstance.
Maybe that's one reason they haven't sued, because
Right.
they might have done their research and they decided, you know what, the
It's not-
partage is really well documented.
Right.
We're not going to go after that.
Yeah.
I'm speculating, but that could be the answer. Yes.
You know about the American hostage prisoners in Iran that were caught along the border a few years ago?
The ones here on the mountains?
Yeah.
Yeah.
Has anybody or any, about, we talk about under-table negotiation between U.S. government and the Iranian, was, this brought up in a discussion, or is there any talks about any case?
It didn't come up in this case.
Because